Raquel West in Jefferson County, Texas. I've seen her before, and usually it is very effective. Now, she's good looking. And sometimes defendant thinks, oh, let me flirt. Yeah, wrong choice. Absolutely wrong choice. Of what I've seen of her, she is on the level of both Judge Simpson and Judge Boyd. She does not take crap from anyone. So, let's move on to Judge West.
Okay, so is EMS coming, or are they already here? Yeah, okay. Okay, Mr. Nichols, Mr. Franklin, on Juan Sanchez. Good morning. Good morning. Good morning. All right, this is cause number 1830854, and sir, you're Juan Sanchez? Yes. And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that. Mr. Nichols let me know that. Then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion.
I'll fetch something to drink. I'll be right back.
And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure.
I kind of agree with you. I don't know this subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible.
Hi, Isabel.
Let me look at the motion
Thank you so much. Yes, we're still here.
Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client
Oh, sorry.
is wanting to stay on probation. And the court may
Thank
take
you,
into
Isabel.
consideration his performance while on probation, including
We are still here.
his payments, his
Port jumping.
support, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay. I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that was initially set for a hearing, and it did specify that date before the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today.
Yeah.
To turn over.
I mean,
Unless
yeah,
There was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happened, chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need to get, I mean,
Right,
that's,
I mean,
that's great.
it's
Everybody
all
can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes. And so I don't know that that would
I
be an
would object to
issue.
that, Your Honor,
At least this is a short.
on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
I'm going to play in
And
1.25.
that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know.
I'm confused by whether there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access this file. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple of weeks or so? Fine with that?
That should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect. Thank you. All right. Y'all are all excused. I'm sorry. No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good. All right. Thank you, y'all.
Thank you.
Oh, that didn't take long, luckily. Let's see what other cases are on the docket.
Is she back there with, is Brittany back there? Which one? That's on Mr. Miller.
A few months ago, she had a case with a guy who showed up in an appropriate shirt, and she went off on him. He had, large guy, and thought he was in front of a tiny little girl. Oh, he just shrunk and shrunk and shrunk, and he had no worth whatsoever when she was done with him. Oh, it was amazing to see. Nobody fucks with Judge Raquel West.
Thank you.
Yeah, and Judge Raquel West
Good morning.
is in
Thank you for coming
252nd
real quick.
District Court in
We'll take care
Jefferson
of Mr. Miller so
County,
they can-
Texas. So we're still south.
Mr. Coleman, we're going to take care of Mr. Miller. It's a competency. All right, this is cause number 241916. And are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Thompson?
No.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
Remind you, we added that on the guy from yesterday, the flight. Charlie.
Oh,
It's not on the docket anywhere, that's why.
and what was it said?
It's just-
An announcement?
Yeah.
What?
Yeah, for you who don't know, Judge West graduated from the St. Mary's University in 1995, which would make her one of the youngest attorneys graduated in history, because she looks late 30s, early 40s at the most. Well, she's not in her late 30s or early 40s. Let's just say that.
Oh, okay. But is it on the, is it going to show
Yes,
up
ma'am.
here?
You may have to refresh your calendar, but it's,
Okay, all right. If, it goes, yes. So the only other option would be to go through the civil, go through a civil commitment would be an option. And so if you get that done, the case can get dismissed and then he can go a different route, but you have to get with your people on how to do that. I know Ms. Mulkino's done it on some, but it, I mean, if it's, obviously there's some issues that need to be taken care of. So perhaps we get the initial competency restoration done and then do it at that time. Yeah. Yeah, how did that feel coming? Oh my gosh, I got so mad that I'm shaking still. Like, I haven't been that frustrated in a long time.
She was
Mr.
elected
Kimler,
judge.
you have Reagan Howard.
She was elected judge in 2014, so she's been at the bench for 11
I
years.
just don't do well with that stance.
Mr. Smith and I are getting along now.
Thank y'all very much. Appreciate that.
There's not a bit of old friends.
That's an interesting way to start the morning.
She'll play sure not to, then I'll ask her. And she did have a female lawyers.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it up to the side, Mr. Smith. There may be evidence he wants to put on that here.
Okay. All right, let me get this. Ms. Howard, in cause number 22-39924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true? The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
Yes, ma'am.
Okay. Count 2 alleges that you're behind in your court assessed fees. And is that true or not true? Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
Yes, ma'am.
Uh-oh.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
Yes, true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
Yes, true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true? Count 7. So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true? And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true? Count 9 alleges that you did not provide verification of performing the community services
She
required. Is that
violated
true or not true?
everything.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as and then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court assessed fees. This is was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true? Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. And if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. And this is unagreed.
Correct,
Jody.
Your Honor, there's no-
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard,
Reasonable
if she were able
bond?
to Post that bond, she would be able to demonstrate to the court.
That's
prior to the
denied.
sentence.
I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a
Yeah.
deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
And we did-
Boom.
You do have her support.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ICE off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kimler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be honest.
Okay, you can go back with the bailiff.
Judicial. Folks, I've been on for 4.5 hours, and now I realize I have not had my tip jar up. Yeah, I'm boomering gratefully. Boomering gratefully. I have my tip jar up if you want to support this channel financially. Never necessary, only deeply appreciated. Do not ever donate or gift what you don't have. I forbid you to gift if you are struggling. Okay? But if you can, if you have the means, I would deeply appreciate it. It is via PayPal. It's pinned on the top of the chat. Thank you. Let's continue. Oh, and
Mr. Matuska, you got Von Zell Hall.
And thank you to Isabel Park who bought me a coffee. Yes, I also have buy me a coffee as a means for support. Everything you can see in the description below.
Good morning.
Or if you buy any other choice, you can always watch my videos, which has ads in
Good
them.
morning. You're Von Zell Hall. And in 24-1747, Mr. Hall is charged with murder. And what is the announcement?
Oh.
The last setting, I requested some digital media. Since then, Mr. Nichols has done an impressive job of providing most everything I need. Unfortunately, I think some of it hasn't been provided to him. And I've discussed this with him. I'm trying to get a few more items I think are pretty important to the situation before we announce. If I could have him a 30-day reset.
There was some follow-up testing and some documentation that he was asking that I don't see in my file, so we need to find out if it exists, where it is, and things like that. So
All right. So I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska and Mr. Hall. Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court date. Okay. All right. You can go back with the bailiff. Thank you.
Your Honor, I've discussed all with him already.
I figure. Thank you. We're, impressive. You've done impressive.
Well, that was a
Can
good
you
thing.
tell, you?
That was a lot, but that's okay. We appreciate that this morning. We're resetting both of Mr. Radford's cases this morning. So, Lenny Leday and Traylon Martin. Okay.
That Cody Dent, one was hired on 2 of the cases,
Mhm.
and Morgan was on other. Morgan just
Yes,
said
I
that
saw
all
that,
the-
Isabel. Thank you so
Okay.
much.
So I put him in the
I
system.
deeply appreciate it.
Okay.
Thank you so much for buying me a coffee.
Okay. And we reset Joel's, correct?
Yes, ma'am.
That's yes. I just so I can get a break. Mr. Rojas on Anthony Williams. Good morning. You're Anthony Williams. And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Williams, in cause number 240401, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sir, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Yes, sir. Mr. Rojas, you have there in Jackson.
Yeah, so yeah, that happens. People show up not looking so well, which kind of is one of the downsides of allegedly committing crimes and being in jail.
Good morning. You're Theron Jackson. And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations on probation for aggravated robbery. Actually, 3 cases, an aggravated robbery and then 2 aggravated assaults with deadly weapons, and cause numbers 24-1324, 1323, and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it?
We have, Your Honor.
Are there any additions or corrections to that report? All
Not from us, sir.
right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. And that, in my opinion, it's like he needs help. The main problems come from mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department in the beginning. He's been on probation for such a short period of time. he's been unable to get the benefit of the resources that probation has to offer. I understand that's because of his not attending probation. But again, I think that all stems from the homelessness and lack of transportation and the mental health issues. He is trying to get help for himself. He does have the application to get his government benefits. He's got contact with someone from MHMR, if he were allowed to stay on probation. He tells me that he has a place to live now. He's going to be living with his cousin who does live here in Beaumont. He is hopeful that he can get his job back at the place he was working for at the barbecue restaurant.
Yeah, that's fine.
Hold on.
And of course, that all is going to depend on him actually going through probation. And he tells me now that he does understand that the importance of getting there, he will do everything he can to make sure that he does get to probation if the court were to allow him to stay on probation. And that's what he's asking the court to do this morning, Judge. And at the proper time, I think he does have a statement to make.
Go ahead.
Hello, my name is Darren Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out of the place. I was staying there. And the same night, the police had came.
Thank you, Isabel. Thank you so much.
Some unpopular, some things that I didn't do. And they said I was under intoxication, but I wasn't, you know what I'm saying? Because they was all fighting and stuff like that. And they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I was intoxicated, and they said I was intoxicated, and they was lying on me. I don't have, they didn't have any record or proof of intoxication.
First of all, thank you, Isabel. Thank you so much. Deeply appreciate it. And then I got the notification from Katrina for $40 from Turnips. Way! Thank you so much. And folks, for you who don't know, I have this week off, so I think that causes for a celebration. And since we are watching a Texas court, Texas shot glass. Thank you so much. Because, I mean, $40 plus Isabel being generous, Film Freak gifted memberships early in the streams, plus super. I mean, seriously, thank you. Thank you so much. And cheers to you all. Oh. Thank you so much. Thank you so No stringable. Even all the small streams leads to a big river. But thank you so much. Thank you so much, everybody. And again, I will say this probably a bit too much often. I forbid you to give if you're struggling. I forbid you. And if you want to make for a good cause, I can give you the links to the Zachariah Anderson Appeals Fund, to the Turtle Boy Defense Fund, to the Innocence Project or something like that. But if you want to support my channel, I deeply appreciate it. But I specifically forbid you to gift if you're struggling. Okay? What did we drink? Van Old Hair blended whiskey. It's my go-to. No, if I say day-to-day whiskey, it sounds weird, but if it's a nice day out, I sit outside with a cigar and a whiskey of some sort, I'm going with that one. I almost said when I mow the lawn, but of course I would not drink and drive.
I got to jail and they released me the next day, for public intoxication. I reported the next day, the day I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. I didn't have no way to get there. So I walked. The next day I waited till it stopped raining.
And now I saw another from Emily. Thank you so much. If you're still here, Emily, thank you so much. If I only use first name because many times via PayPal, you have your actual name, and sometimes you don't want me to pronounce the entire name. So just first name. So thank you, Emily, for Emily Stringerbell. Yay! Thank you so much. Thank you. Thank you for 549. Thank you. Thank you so much.
And it was unflooded. And I walked to the probation office, and I told the lady that I didn't have my social security card and my ID, and she said she was going to help me do it. I was very excited, Judge, trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house while I was staying there, and I had to move in a hotel room, and I ran out of money, and bro, it just all went downhill from there. Yeah. And I if you can find any way for me to get back on probation, I promise I'm going to do the right thing. And you know, I'm a good citizen, and I help anybody I can. I'm a minister of music. I go to church, Solid Rock, Church of God Christ, and yeah, man, I've been trying to stay out of trouble. I just been running on hard times. Yeah. I just need a second chance.
Ms. Monfino?
Judge, I'm not unsympathetic to his situation. I don't think it's something that he's just coming in today saying that he's had these problems. I think they've been ongoing. I think that's why we had initially wanted to give him the opportunity of probation so that he could participate in the mental health caseload. Obviously, he's very lucky to have him score as his officer, but I have spoken with her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say, these are the resources we try to have to help you, and they just can't ever find them. I'm not suggesting that necessarily my position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and he does not do what Ms. Ford needs him to do, that the court orders him to do, that the recommendation would be significantly higher than it would be today for revocation based on that.
You probably haven't even had enough time to know. I guess my question, Ms. Core, would be, if I continue him on probation, would something like cognitive track of ISF be
Yes, ma'am.
helpful, or that, or either special needs safety? Which one do you think would be more appropriate to help him get a good start before he gets back out?
I would think very highly of the special needs safety for him.
Okay. I mean, Mr. Jackson, everybody wants you to be successful,
Yes, ma'am.
but you're the only one that can make that happen. You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you. So if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment, it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here, and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation right now today, for life, for 50 years, for 30 years, for 20 years, an aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right. So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of SafeP. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Moore. Ashley Faye, Mr. Rojas. Good morning.
Jeff, we think we can do this, but she does 3 prior state jail felonies on the same day. They're not sequenced, but I think we can still do a third degree.
Yeah, they don't have to be sequenced. Only regular ones to make it a second degree have to be sequenced.
We're worried.
That's our old drug court days.
Right.
Toby, you should remember that.
But I looked at them with all the same day. I'm like,
Yeah, I remember that from those days. Okay, so she's gonna go. Let me say this the right way.
The audit sheet's been in.
Thank you. Good morning. Are you Ashley Faye? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Faye, in cause number 250355, you are charged with the state jail felony offense of credit or debit card abuse from October 16th of 2024. Your indictment alleges that you were previously convicted of theft, a state jail felony, March 15th of 2019, in 3 different state jail felony cases of theft on that same date. And how do you plead to the charge? And are those prior theft convictions true? Answer out loud, please. Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you not understand something?
No, ma'am, I kind of wanted to ask for probation.
So this isn't where you do that. Y'all have negotiated with Mr. Rojas. Mr. Rojas negotiates with Mr. Hoffpower. They do all of that. I don't get involved in that process. So there's a couple of things you can do.
Is his name Half Power? That's an interesting choice.
You can go ahead, Mr. Rojas.
So we did have an offer for a cab judge. We talked about that, and this is the one that she chose. If you have a second thoughts, we can talk about that some more.
Do you want to go talk to Mr. Rojas about that cap? The cap would be pleading open to me, where I could give you time in prison. I could give you probation. It would depend on all the information that I was given at a later hearing for a sentencing hearing. If you want to do that, then you do want to do that. I think you're going to have to do the different.
Yeah, but it's different people.
No, you're not. With everybody's permission, I can make those changes on this.
Yes, ma'am.
What is it? Cap of what?
Cap of 5.
How do I? No, it's not. It's writing with it. So I'm just scribbling on it. So on the agreed punishment recommendation page, I am marking off the cap of 5. And then I think that's really the only thing that needs to be changed. Okay, so then let's go back. The agreement that you've reached is for a cap of 5 years. And I want to make sure you understand, it sounds like you've gone over it with Mr. Rojas, that what that means is that you're leaving your punishment up to me. As long as I give you 5 years or less, I can consider probation, you cannot appeal. Do you understand? And you have an absolute right to have a jury come in and determine if you're guilty or not. You can leave your punishment up to a jury. If we go forward this way, you're waiving that right. And is that what you want to do? Right. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence in this phase not competent?
No, yeah.
All right, ma'am, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a report that'll give me more information about you, your history, your cases, and then we'll come back for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff. Yes, ma'am. Do you have anything else?
The add-on.
Oh, okay.
Yeah, thank you, Isabel. Nick got a lot of accolades when he did the interview with I can't remember who, and I assume you are talking about the $1 billion defamation case, Young versus CNN, where I had Mr. Devin on his defense attorney or his attorney for well over an hour, just talking about the case and future cases. And he got CNN to settle. Now, he already won $5 million in the first part of the defamation trial, and then it was time for the jury to decide, okay, what will go on top of it. And later, a juror said they were talking about in the region of $100 to $200 million in fines towards CNN, but CNN decided to settle, and he wouldn't give me numbers, but I would assure you they did not settle under $50 million. And here's something fun about the Young versus CNN case. Mr. Young is now suing Fox because they took in everything CNN did, and even after the trial, Fox refused to take the articles down. So now he's suing Fox. So that's interesting. Not with the same attorney, but once I find the information, I will give an update on that case as well. I covered the Young versus CNN. When was that? Dun, dun, dun. That was way back in the $1 billion defamation. That was in January of this year. And the interview is from January 26 with Devin Velvel Friedman. Let's see here. Here is the link to that. He works out of Miami, Florida, and hopefully when I get to Miami, September 18, 19, 20, I can have a meeting with him. Yeah, for you who don't know, hi, I'm going to the United States in September. I'm spending September 13 to 18 in Utah, and then a week in Miami. And September 20th, me and Steve Gosney will have a meetup in Miami, somewhere in central Miami, at a bar. Food and bar stuff, food and bar place. So if you have the chance and means, yeah, I would love to have you there.
That's for bond.
That's the one from.
Yes, I will be visiting Jeff in Utah. That is the main reason I'm going to Utah. I'm also meeting up with Connor and Damian.
Of course I did.
And then I will be
remember that.
traveling around and visiting old Western movie scenery sites.
Oh. Yeah, and okay, but if nothing was filed, she just made the request of let's get Janicia Leonard out, and I'll just put it on the record since they. I just decided to, well, and what went on, I don't know if you know, last week I received a message from Judge,
The jail has a policy in place for that. Maybe
Yeah, last year I
I'm not concerned about it necessarily.
Last year in August, I went on a road trip from south to north. So I went to Houston, New Orleans, Atlanta, where I visited the YSL trial, that courtroom. I also visited Chattanooga, Knoxville, Delphi, Indiana. I actually went to Delphi, Indiana, and then up to Detroit. And then I flew home again. So I had a 19-day road trip across the United States last year.
Just wanted to put something on the record because she made, I guess, enough impression on Judge DeRuin. And so even without a motion, I just wanted to at least put some stuff on the record. And then obviously if at a certain, I'm not going to set a bond today, but I'm going to explain where we are, why there's not a bond. And then if you want to file something and we have time for a hearing with some specific information, once you kind of get, then I'll reconsider it. But let's just. Yeah, well, there's that. The only thing, the issue, one of the issues I have is the new case. It's from 23. And so actually I might consider a bond just because if she hasn't been arrested since 23. Let me look at.
I would want 3 days to prepare, but if
we can reset it for next week. I just want.
If you want to do it today, I'm not supposed to do it today. My argument with you, Judge, is it's follows.
Yeah, I just the length of time. I want to know if she's been doing well on probation. Other than that, that's one thing I would like to know. And so I think let's reset it for next.
We can reset it.
Let's do that. Let's reset it. Tell Sharon, never mind. Let's reset Miss Leonard for next week, and then I would like to have. I think Miss Core already left. Miss Core was her. That's okay for next week if she can be here, just so that I can, because of the length of time of that new offense allegation and when it was indicted. I think I'll consider that, and that'll give you time also, Mr. Coleman, to see what's going on and what we can do. All right. Thank you. Mr. Samuel, you have Cody Dent.
Yes, Your Honor.
Good morning.
I will discuss that, so I'll be filing that afterwards.
Okay. If you're requesting, make sure since you're hired, you'll have to do an affidavit of indigency if you're asking the county to pay for anything.
I will.
So make sure you attach that with it. When you
Okay.
do it. Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week, if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
so it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off? Just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay. So but you still think give you a week to get up to speed.
Correct.
Bond hearing next week.
Correct.
And then I'll look at your motion for the evaluation. We'll take care of that.
And
Right.
I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we? Yes. We're good. Okay. We'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
When you're finished, come sit down. So he does need to fill out. Here's an affidavit.
Mr. Lewis on Justin Franklin. Good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I understand the complaint wouldn't have been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Will you call the name Kayla Davis, please?
Okay.
Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead? and Put
Go
something on the
ahead,
record?
Judge, if you
Okay.
just want to swear your-
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record? And Ms. Davis, what is your relationship to the defendant, Justin Franklin?
He's my husband.
Okay, and how long have you all been married?
We got married in January.
In January? And you know what we're here about today, right?
Yes.
The aggravated robbery that he's alleged to have committed against you and your children, right?
Yes.
Where he held you all at gunpoint and stole your purse and wallet, right?
He didn't kill us in gunpoint. He didn't steal my purse. Nor my wallet.
Did you tell the police that that's what happened?
No, ma'am.
So if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office, asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state,
Yes, I
correct?
have.
Are you in fear of Mr. Franklin
I'm not.
pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety,
Yes, I do.
and that's what you want me to do?
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to allow
Judge
me
West
to
to-
drop the case.
Drop the case.
All right. All right. You can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I both had in the past. I think there's something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right. If that comes through based on all of that, I don't know how you can do anything else. And so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on. Just let me talk. Okay. Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff. Yes, ma'am.
Okay. Another one of these cases where the accusing party retracts. Now, over here, that's really not a possibility. Unless the entire case is completely dependent on that person. Then it's not much they can do. But for instance, in DV cases here, the first thing cops do is take a fuck ton of pictures. Interview, record the interview. Boom, boom, boom. Everything is clear cut, bum, bum, bum. So even if the complaining party or the DV victim later on retracts it for whatever reason, they will still move on with the evidence because they don't need that person anymore. And that is because it's not unusual for victims of DV because, oh, I didn't mean it. Oh, I will be better. Oh, all of that, which is most often bullshit. Yeah, that guy needs to, or girl, yeah, girls too, needs to be in prison. And hopefully during that time, somebody can get to the victim, hey, you deserve better. Because they always do. Nobody deserves to be a victim of DV. Now, if it is a destructive relationship, just walk away, please. And I know it's hard, but please just walk away. I mean, we have here in Sweden, I mean, we don't have many murders here in Sweden. We maybe have in the entirety of the country. Let's see, what's the statistics? Lethal violence. Jesus Christ. We have so stupid statistic always breaks everything down. Yeah, okay. We had last year about somewhere around 30 DV murders. All women were murdered by their spouse. And it is sadly a very common outcome, either complete murder or attempted murder or just kept on beating. So please walk away. You always deserve
Mr.
better.
Parker, you Tracy Haynes. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd, 2025, with that report from Dr. Samantha Guzman, with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
There you are. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
There you go.
And are we going on count one only? Hold on, let me get it correct. Yeah. All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. State Senators number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent again and that you understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.